Next, from the Illinois Supreme Court's Chicago offices, an Illinois Channel profile, our one-on-one conversation with retiring Supreme Court Justice Mary Ann McMorrow. Justice McMorrow established a number of firsts within her career. She was the first woman elected to the Illinois Supreme Court, the first to serve as Chief Justice of the court, and the first woman in Illinois history to lead one of the three branches of government. We speak with her about her career, the courts in Illinois, and the evolving role of women in the legal profession. This runs about 40 minutes.
Justice Mary Ann McMorrow, thank you so much for joining us on the Illinois Channel.
You're welcome. I'm happy to be here.
You are, I think, safe to say, you are in your own way, even if you don't feel this way, a historic figure. You are a trailblazer for your gender, at least, within the legal profession within Illinois. The first woman, as I understand it, to prosecute felonies in Cook County.
Yes.
The first woman to be on the Illinois Supreme Court, and the first woman to serve as Chief Justice.
Yes.
What is your own reflection at this point as you're looking to leave the bench in a few days? What do you think about your own career? Are you surprised yourself at what you've achieved?
Well, I think that it was very exciting, very challenging, but more importantly, I think I was very blessed in being in the right place at the right time, and in being in a position where I could do some of these things, and where I could think about doing some things that had not been done before. So I'm grateful, really, for the opportunities that I had.
I want to get into some of the various aspects of your career, but let's start first with just some of your background. Tell us, where did you grow up, and let's go through some of the early years and how you eventually led into a legal career.
All right. I was the middle of three children born to parents who lived and always lived on the northwest side of Chicago. All of our schooling was on the northwest side of Chicago. My brother was 2 years older. My sister is 2 years younger. My brother is now deceased, as are my parents. My sister is still living. We went to school under the direction, really, of parents who were very fussy about getting good grades in school and the value of study. My mother admired Eleanor Roosevelt a great deal, and often told us how poor Eleanor might not have been an attractive woman, but she was a very learned woman, and she was so because her family knew that she wouldn't be attractive and tried to make it up by having her receive a good education. So my parents, they probably thought I wouldn't be attractive either, and wanted me to have, and my sister and brother also. We all graduated from university. We all graduated from
What university did you go to?
I'm sorry?
What university?
Loyola University. My brother was a great track star. He ran in track meets all over the country. He was considered Olympic material. So he went to Marquette for 1 or 2 years, but then transferred back to Loyola. And my sister and I also were there, graduated from there.
You've told the story in public speeches how you were having a sleepover one night.
Yes.
I'm not sure when that was, but that your mother offhandedly made a comment to you about, have you ever thought about going to law school? And that eventually that kind of led you into thinking of going into the law.
Yes. When I was in high school, my dearest friends were women. It was an all-girls school. Women or girls who liked to debate, and we debated every imaginable thing, to the point where we wondered if there were beans in a can of beans. It was really extreme. And we would take turns sleeping at someone's home, and one time when they were at my home, and we would debate and argue until early hours of the morning. We all enjoyed that. It was a challenge for each of us. And my mother, of course, listened in, you know, and as mothers do. And the next day she said to me, in a very casual, offhanded way, have you ever thought of going to law school? And my answer was no, because women did go to law school at that time. But the thought stayed with me. And several years later, I thought about it some more and thought, why not? And enrolled in law school when I did my undergraduate work, when I completed my undergraduate work.
So it just kind of was almost a planting of a seed that really didn't blossom then, I guess, for a couple of years, you say?
Right, Terry, you're absolutely right. It was a seed that lay dormant for some time, but then surfaced.
So you went to Loyola and you had your undergraduate degree, and what was that in?
Rosary. It was known as Rosary College at that time. Now it's known as Dominican University.
Oh, okay. Mm-hmm.
But it was a typical undergraduate work, the core courses for the most part.
Mm-hmm.
Of the members of my family, things came easily to me. I didn't have to study as long or as hard as some others did. My sister was the popular one. She was always class president. My brother was this nationally known athlete, and then I was in the middle with nothing, so I studied, and things came easily to me. With one exception, when I was at Rosary, as it was then known, I had difficulty with French, and I couldn't wait to get out of there because I, for the first time, worried about passing a course and never had that problem before. But eventually I passed and was able to go to Loyola Law School.
So you go to law school and you become an attorney in 1953.
Yes.
What was the chronology then of you starting your family and you entering the legal profession, as far as, and you practiced kind of general law initially? Is that
Yes, right? Yes. When I left law school after I got my degree and got my license, I got my license the same year, then the university, Loyola University School of Law, asked me to return and work for it in connection with a Ford Foundation grant that the university had received. And the grant pertained to doing a piece or a study on integration in the schools in Chicago. That's been pretty well developed now, but at that time it was not. It was still developing. So I did research for the law school for almost a year, after which I went to work in a law firm, rather small law firm, but it was a diversified practice, so I got good experience there. I stayed there, I don't remember, Terry, how long, but it might have been 2 years or 3 years, something like that. We're going back a long, long way now.
So that's roughly the mid-50s, I guess.
No, it would have been the later 50s.
Late 50s? Okay.
Yes. And then I received an invitation to go to the state's attorney's office, and I accepted that because the work would be a little bit different. But much to my surprise, I was shocked actually to find out I was assigned to the criminal division, and I had never, when I was in law school, pictured myself as doing criminal work, prosecuting or defending. Actually, I didn't even pay too much attention to the criminal law courses as we were being taught.
Thinking that you wouldn't practice
Right. I thought, well, I'm not going to pay too much attention to this because I'll never be doing this kind of work. But I found myself enjoying every minute of it. It was exciting. It was real life. It was dealing with human
Gritty
beings.
and not just theoretical.
Right. Exactly. So then I became a prosecutor, and I stayed in the state's attorney's office. I don't recall exactly how many years it was, but it must have been about 6 or 7. And I left, and the only reason I left was I got married. Got married in 1962, and got pregnant, and was giving birth to my daughter, so I asked to take a leave of absence. And now a leave of absence is very common, but at that time nobody knew what it was to get a leave of absence, particularly for maternity reasons. So the bosses just said, yes, anything you want, and they weren't going to question it. I was obviously pregnant, and I left to give birth to my daughter. And she wasn't feeling well when she was born, and you have to understand that my husband and I were both older when we got married. My husband was 42, and I was 32. So having a baby, and particularly a little girl, he adored her, was a dream come true for both of us. Matter of fact, as soon as he found out I was pregnant, he was determined that it was going to be a little girl, and she was going to be named Mary Ann. And no no discussion, no further discussion. It was going to be little Mary Ann, and when we found out it was a little girl and she was fine, I suggested we name her Mary Lynn or Mary Frances or something else, you know, so there would be no confusion. But he wouldn't budge. It was going to be Mary Ann and nothing but. But it was. Then I left the state's attorney's office and practiced as an individual practitioner for a while before one of my friends, well, several of my friends with whom I worked in the state's attorney's office suggested I run for judge. And I was hesitant to do that and thought that when and if I ever did that, I would speak to someone who had know-how or political know-how, who would guide me or advise me. And we came down to 2 days before the deadline for filing, and I couldn't reach this person. And so I was getting a little bit nervous, but eventually I reached him the night before, and he told me to go ahead and file anyway. He said he couldn't support me because he had already committed to someone else, but he said, who knows, you know, you just never know how these things turn out. And so I went ahead and filed anyway. And I appeared before the slate makers, which again was a new experience for me. We were told, do you want me to just go on?
Sure, go ahead.
Okay. We were told when we waited in line, because there were a whole line of people, quite a few people, waiting to appear before the slate makers so that we might be endorsed by the Democratic political party when we ran. And we were told that we would have 4 minutes in which to make our presentations. The other Mayor Daley, the present Mayor Daley's father, was chair of that committee, and Jane Byrne was the vice chair of that committee. And so I had my speech, my presentation, planned right down to the full 4 minutes. I timed myself repeatedly in front of a kitchen clock that has a second hand on it, and I had it down to exactly 4 minutes. And while we waited in line, it was getting closer to lunch hour, a man came by and told all of us they were running late and to cut our speeches or our presentations down to 3 minutes. So I decided what I could cut out, and while we waited in line longer, he came by again and asked that we all, not just me, but all of us, shorten our presentations to 2 minutes. And of course that was difficult after planning it, you know, in terms of 4 minutes. But then he came around again. It was getting close to 1 o'clock in the afternoon and nobody had lunch. He asked all of us to shorten it to 1 minute. And I thought about it and I thought, well, that's, you know, that's too much. So when I went in, I just used my full 4 minutes and gave my 4 minute speech. And they listened very attentively. And I did not go in and talk about how great I was or things that most candidates do talk about, or that I had done any work for the political party, because I hadn't. I told them primarily that at that time, which was in the 70s, and that's when this turnabout started to proceed, that would behoove both political parties, both the Democratic Party and the Republican Party, to slate more women, because the law schools were getting a much greater enrollment of women, and there would be a substantial increase in the number of women who would be practicing law. And it clicked with them, and they slated me. So that's how I got started.
Well, let me ask you, because we often say that justice is blind, and we have the scales of justice with
Yes.
the blindfold on. Why does it matter if the law is the law, that we have women on the bench, or we have blacks on the bench, or does it matter if we had all women on the Supreme Court? What difference does that make?
It should make none. None. I wanted to emphasize that. I'm glad you asked me that question. It should make no difference how that person who's sitting up there looks. The law is the same for men and for women. We bring a different perspective, but the law is the same for men or for women. And I think the American dream, or Americana, is such that we wouldn't even notice whether it's a man or a woman up there, or black or white or an Asian, whatever. If we reach that American dream, we wouldn't notice that. And we're getting better, but we haven't reached it yet.
And I wonder, when we say the law is the law, sometimes, would I be correct, I've not been a judge or even a lawyer, that there's always that gray area, we say, of the law. Is that where the perspective, the human experience comes to play, or do you not? As an example, when you being the first woman, well, then you were the first mother to sit as a member of the court. Did you find that cases would come up where that your life experiences, which were different than your male counterparts, played a role in the way that you either interpreted the case, not necessarily applied the law, but that maybe you picked up on some elements of the case, perhaps stood out to you more than your male counterparts?
You're very correct. Each of us are product of our experiences in our backgrounds. And what we bring to the court is what we have been all our lives, our education and our experiences. Women's experiences have been different than men's for the very reasons that you articulated. Women, they don't really interpret law different, but they bring a different perspective, a different attitude towards the law. For example, when I went on to the Supreme Court appoints committees, and there were 1 or 2 committees that had 20 members on it, and they were all men. It isn't that the men who were on the court and who made these appointments meant to eliminate women, or denigrated women in any way. They just didn't. They didn't notice that there were no women on those committees. It's just a matter of enlightening a little bit, which is what I did. There are no women on these committees, but it's just a matter of approach, really, and perspective. The interpretation of the law should be similar or the same, but we come with different backgrounds, and we're supposed to bring that to the bench. We are each elected, and certainly in Illinois we're all elected, based upon our life experiences. And mine are different than maybe one of my male classmates was.
One of the, I think, funny stories you told, funny and also poignant, was early in your career when you were practicing, you were going to argue a case before the Illinois Supreme Court, but the law partner put the kibosh on that, as I understand it. Can you tell that story?
Yes. When I was in the state's attorney's office, the man who was in charge of appeals asked me if I would like to argue a case before the Supreme Court of Illinois. And I was a young attorney, and I was thrilled when he asked me. I was really excited about this. I said, oh, of course. So I prepared the case. I prepared the brief that has to be submitted, and I prepared my oral argument, exactly what I was going to say and how long. We're limited in time again. And 2 days before I was supposed to go, not my partner, but the boss said, and he had to be told I was going because, what if we had an automobile accident or something along the way? He should know where his people are. So we told him that I was going to argue this particular case, and he said, oh no, we don't have women arguing in the Supreme Court. And I was greatly disturbed by that, although I didn't say anything to him. But I had, again, been thrilled to have been asked and worked hard on this particular case. And I couldn't go. I wasn't permitted to go. And now, many, many years later, when I sat on the court, indeed, when I was Chief Justice, I thought, here, I'm sitting on the very court before which I wasn't permitted to argue. And now there are many women arguing, and they do such a good job. And I thought, why couldn't women have done that before? What a tremendous waste of talent there was in not permitting them to argue. It was just a tremendous waste, I thought. But things are much better now. Matter of fact, I think about approximately half of the lawyers who argue before the court are women. This is just my approximation.
As you look back over the period of time that you've been both an attorney and a judge, how has the law changed? How has the practice of law changed? Has it changed? Is it primarily in the opening up to other individuals that the legal profession is becoming more diversified?
Oh yes, it's become tremendously more diversified. That's one change. The profession is now open, and most people know this. It's open to women, it's open to African Americans, it's open to the Asian community. None of these groups before had even gone to law school, much less practice law or become judges. So there are quite a few who now practice law and who have become judges at various levels. But in addition to that, the law has changed in many other ways. The law now has, each school has ethics courses, and each of us studies ethics both while we're there and after we graduate. The discovery process, which I'm not sure you're familiar with, but before a case is tried, the lawyers for both sides have the right to what we call discovery. They have the right to know what's in the file of their opposing counsel, so that there should be really no surprises. These are not games. These are searches for truth, the trials, and there should not be any surprises. Lawyers for both sides should be familiar with what the other side is going to present, and that's a tremendous advance. In the criminal law field, and in the death penalty field in particular, we have had a number of reforms. And Illinois is now in the forefront of reforms in the area of death penalty cases.
When you became Chief Justice, and let's take a little diversion across from personal, just explain to our audience, what is the role of the Chief Justice of the Illinois Supreme Court?
The Chief Justice of the Illinois Supreme Court is elected by his or her fellow justices for a 3-year term. It's always for 3 years. The Chief Justice has the responsibility of assigning cases to the other judges. And we do it by pretty much by rote, by automatically
An order?
by seniority. Okay? We don't do it according to expertise, and that surprised me a little. I thought if someone had great expertise in a particular area like municipal law, like we had Justice Bolandic, who had been a mayor and an alderman before, so he had both executive and administrative experience. We didn't give him cases involving city problems.
And why is that? Why not?
Well, it makes for fairness, so that not one person gets all of a certain kind of cases. And those judges who practiced criminal law before didn't get all the criminal cases. Those were divided, particularly when we had death penalty cases. Those always take a lot more time, and they should. So it would be unfair to burden one judge with all of those. Now, and for all the years I've been on the court, they're assigned by rotation is really what it is, according to seniority.
Other thing, I was going to say, the other thing you do, isn't it true that you also have to put together the budget and go before the appropriation committee and the legislature to have the judicial branch get their funding?
Yes, that was quite an experience for me. I had never done that before, and I appeared before the appropriations committee, before the House and the Senate. We never learned anything in law school that prepared us for that, And the legislators, of course, present questions to us. So it was a challenging experience for me. And the legislators were very nice to me, though. I must say I enjoyed it.
What did you take from that? Would you say, how are the courts in Illinois funded? Are they funded appropriately? Are they underfunded? Just what's the status of the
At
judiciary?
the present time, I think they're underfunded. We operate on a very strict budget. The administrative office administers the budget, really. But when you take out the salaries, which are mandatory, those are established by the legislature. When you take out the salaries that must be paid, then there's little room for extras. We have virtually no funding for out-of-travel programs that would be beneficial to the court. We are on a strict budget with respect to our committee work right in our own state. There's really little funds available to do things that are very worthwhile and would be very helpful to the court. but there just isn't money for them.
You know, I also had heard some people had brought up to me that the funding differential, let's say for the indigent in a criminal trial, that Illinois is grossly underfunded as compared to some of the other states.
Yes, yes. Well, we have a public defender system, which is helpful, of course, and we have pro bono agencies which help the poor who cannot afford legal counsel, but they're both inadequate for the need, for the number of people who need these services. They're not adequate.
Why is, I mean, did you ever have discussions? Did you try to get more money when you were Chief Justice? And if so, what kind of attitude did you run into from the various committees?
Well, the legislators, for the most part, there were two who didn't belong to the general group, but for the most part, the legislators understood the tight budget that we were operating under and understood that we could not do things that we wanted to do. There were two legislators who felt that, or who believed and stated that we could do like, why do we have two chambers? Why do I have a chamber here in Chicago and a chamber in Springfield? Well, we have to have that because we work out of both. We have to have a chambers in Springfield so that we can meet with the other judges and have conduct court there, conduct our court and oral arguments there. And then when we leave there, we come to our local district offices or chambers to do our research and our writing. We prepare our opinions here. We consider motions here. We do all kinds of work here in our local chambers that we don't have to be in Springfield for. But he didn't know why we had two chambers. Then now in the last year or two, security has become a big problem too.
And just the cost of incurring that as well.
Yes, yes.
Let me go, when you became Chief Justice, what were some of the items on your agenda that you wanted to achieve during your 3 years?
Oh, I had several. I wanted to permit the judges to again be able to teach in the law schools, provided the teaching didn't interfere with their court time. They could not teach, of course, when they should have been in their courtrooms. But a few years ago, they were prohibited from teaching at all. And that was really unfortunate because law schools lost the benefit of their experience. And it's good experience that they could bring to those students. I mean, it was practical. They were in the courtrooms. They saw and heard what was going on and what should be done. So it was very good experience that should be shared with students.
And they were prohibited from doing that?
Right, from the rule was changed. So I got the rule changed back to what it was before, where they could teach with the permission of their chief judge. Again, it was provided that it wouldn't interfere with their court work and their court time. One of the other things that was very important to me was to do away with the liability of lawyers for the conduct of their fellow lawyers who might be in another state. I'm trying to simplify this a little bit. Some of the law firms, quite a few of them, have offices all over the world, really. And the law was such that if a lawyer in California or in Japan did something wrong or was negligent in some way, and the client was filing suit against that lawyer in that firm, a lawyer here in Chicago who had no knowledge whatsoever of the case or what was done could be held personally liable. And the lawyer in Chicago's bank accounts, personal assets, home, they could have all been subject to attachment. And I thought that was unfair. Illinois was one of the last states to hold out on that. And to me, it was very important that we change that rule and that we come in line with the rule in the other states, which still protects the clients. They're not without protection because they should not be. But it prevents them from filing suit against somebody in another state or another part of that law firm business that has no knowledge whatsoever. They still have, they're protected, as I said, but this type of liability has been dismissed.
But it was the civility, was that
civility
something?
Was a big subject at that time too. It seems like over the years lawyers got not only more casual but more uncivil towards each other. They might promise each other to make telephone calls and then fail to do that, fail to return calls when one or the other would ask if a continuance could be had in a case, or fail to ask for discovery again, which is where we exchange
Working
information.
together as far as the sharing of information.
Where they could not be present for discovery and didn't let you know in advance. And you might have experts waiting to be deposed to be part of this discovery process. And experts are always very costly.
Let me ask something. Do you think, given the state of affairs, is the judicial system dispensing justice?
Yes, I think we are. Even with all the financial restrictions that we have, I do think we're doing a good job, and I think the judges are doing a good job. Much, much improved over what it was when I started out in many, many ways. I think we're doing the best job we can. Well, there's always room for improvement. When I say doing the best job we can, I don't mean that there isn't room for improvement, because there always is. But they're doing a good job for the most part. You have an occasional instance where a judge didn't perform as he or she should, but those are becoming more and more rare. Of the number of lawyers who practice in Chicago, not in Chicago, in the state of Illinois, there are approximately 80,000 lawyers. You only get about 1 or 2 cases, well, I should say a little bit more, maybe between 5 and 10 cases in a year, which a lawyer is disbarred. And when you think about 80,000, 10 isn't very much.
You know, to what extent we look at, here at the moment we still have this moratorium on the death penalty.
Yes.
It's talking about how the law is and whether there's justice being done. And of course that happened under Governor Ryan. It's been continued under Governor Blagojevich.
Yes.
And it happened under Governor Ryan for the reasons we all now know, that any number of people were on death row, and it turned out that they apparently were not guilty of that to which they had been convicted. Part of this discussion and part of those who were proved to be innocent, sometimes it was because of DNA. Let's just talk about the death penalty, that situation, and also about how technology, such as DNA, changes the law. I think a lot of lay people think of the law as being this stagnant body of rules, but it's really a dynamic force that kind of changes both from the legislature as well as the impact of outside forces such as technology.
Yes, it's interesting you should mention this. 3 days ago I returned from Beijing, China, where I presented a paper in the Illinois view of the death penalty and the reforms, why we needed them and what we now have in the way of reforms for the Chinese people, the Chinese Supreme Court justices and lawyers and professors. DNA was not available when many of these prisoners, and they were prisoners at the time, were convicted. Some of them were on death row in prisons for 10, 15, I think one even 20 years. And then DNA came along, and DNA testing would prove that they were not the guilty party, but that was not available at the time they were convicted. And part of our other reforms included establishing what we call a capital litigation bar. That means the lawyers who try death penalty cases, who defend them and who prosecute them, both must have special training and be certified to be a part of that capital litigation bar. Also, the judges who hear those cases now must also be specially trained in presiding over trials in which the death penalty is being sought. So you've got now lawyers and the judge who are more
they're becoming specialties like as we have in medicine. Huh?
Yes, yes, very much so. We needed it. We needed it.
And for the same reasons.
For the same reason.
Body of knowledge continues to change, and you have to stay current, I guess.
Correct, right. Terry, you'd be very good on all of this. You're very knowledgeable. There were other reforms. that were necessary that Governor Ryan instituted. We still have the moratorium. Our present governor continued it. Doesn't mean that in the trial courts or in the courts of review that death penalty cases are not being argued. In the trial courts, prosecutors are still asking and getting death penalty verdicts, and we review them, but they're not being executed. If a person now is getting a death penalty, a verdict or sentence, he will remain in prison, but he won't be executed until the moratorium is lifted. In other words, the death penalty statute is still in place, but the execution is suspended.
Of course, it's up to the, I'd say, the political forces in the legislature, and we'll see when that changes. But because time will run out, and I could spend many more hours talking to you, but we don't have that time. Let me ask you two things more. One, as you look back on your career, just give us a general overview. What's I would suspect you'd have to be satisfied with your career. Do you have regrets too, or just give us your thoughts as you look back?
No, I have no regrets. I leave with a feeling of great satisfaction, not because of my work, but because of the opportunities that are now available and that I may have in some way made possible that were not available before. Now there's really nothing that women cannot do, or no job or type of trial that they cannot handle.
And you find that is gone.
Oh, yes,
the built-in prejudice, so to speak, that you faced is gone now.
But now, even in the federal courts, they try and defend antitrust cases. Before, when I became a lawyer, at most they were permitted to try divorce cases, traffic court cases, and probate, but they weren't permitted to go beyond that very much. It just wasn't open to them. But now every field is open to them, and they're doing very well, which means there were many back then that would have done very well also. I just feel very fortunate that, looking back on my career, that I was there when I was, and I had people around me, mentors and bosses and superiors, who gave me an opening, who gave me a chance to do things that had not been done before. Because without them, it might not have turned out this way. I worked hard, I worked very hard, but as I always tell new lawyers and new judges, be the best that you can be and become the best that you can. Don't compromise and settle for anything less. Work hard, because really, truly great men and women work hard. They do. And they do over and above what might be expected of them. And it's the extraordinary that you can become rather than the ordinary. It's the excellent that you can become rather than good. There's just lots of possibilities. If you're willing to work, you have to do that. And find it enjoyable along the way, which I did. I enjoyed it tremendously.
As we tape this, we're roughly you have one more week or so in a few days on the bench. What's the future? What will you be doing once you leave the bench?
I have several offers at the present time. I would like a couple of weeks rest to just sit back and consider all the options. I have been offered a chance to teach. I received an offer from a law firm to come and work there. I received an offer to come and use law office space if I wanted to have my own practice. And I am also considering, at the request and suggestion of someone whom I respect, the opportunity to mediate and arbitrate. I didn't consider that before, but after listening to him, I'm thinking about that also. So I thought, well, I'll just enjoy it for a little bit, because I've been working actually since I've been in high school without a stop. So this is my first chance to do what I want and when I want for a while. Every vacation that I have had involved taking about 1/3 of my luggage space filled with briefs, you know, it's been it's busy. I worked hard, but it was well worth it. I enjoyed it in the process. It was fun. It was challenging. The men were very open and receptive to me. I experienced very little discrimination, very little. And much depends upon the person, I think. You can accomplish a great deal without being confrontational.
Well, that's a good place probably to close. That's a good quote. But I just want to thank you again for taking the time to share your thoughts with us, and good luck to you in the future.
Well, thank you. I enjoyed being with you and meeting you, and I wish Illinois Channel continued success. I've had experience with you before, as you know, and it's always been pleasant and good. Thank you.
Thanks so much.
Thank you.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois. Thanks for watching, and if you haven't already, please consider subscribing to our channel. And while you're at it, please leave us a comment. Thank you for watching.